Gaming review videos are some of the more mild forms of content found on YouTube. Listening to someone talk about the strengths and weaknesses of different games while discussing their own experience is quite enjoyable to listen to from time to time. Unfortunately, even a community as wholesome sounding as this has its bad apples. And one bad apple who's fallen quite far from the tree and now sticks out like a sore thumb amongst the rest is a creator named Acerthorn. Some of you might already know who this individual is, or at least are familiar with the name, as his shitty behavior and abuse of the copyright system on YouTube is finally coming to light, with creators like Mutahar and Sid Alpha covering the situation, the latter of which is the latest creator that Acerthorn has named in an ongoing lawsuit against a bunch of other creators. What's up guys, and welcome back to the channel. Or if you're new here, then welcome. I'm Redski, and today I'll be showcasing Acerthorn, or as I like to call him, the legal lolcow. For those of you watching who don't know who he is, Acerthorn is a small gaming content creator who first gained notoriety from his video game review essays. I checked a few of these reviews out for myself, and while I thought at first he was playing a character, the behavior this man exhibits outside of his video essays leads me to believe otherwise. This can easily be seen with how he responds to seemingly any amount of criticism levied at him. As you can imagine, this man has a level of sensitivity that makes deaf noodles look tame in comparison. Before I continue any further, I want to give a quick shout out to a viewer of mine named Versus who notified me of this entire situation. This video would not have been made without her help, as well as a shout out to all the creators who have had to put up with Acerthorn and his antics. You guys are truly patient. I want to make one thing clear, and that is to not send any form of harassment to Acerthorn or any of the creators that I mentioned in this video. While Acerthorn engages in harassing others and abuses the system to try and silence criticism, I do not condone the same being done to him, regardless of what he's done. Let's not stoop down to his level. This video is meant to document Acerthorn's past when it comes to the way he handles lawsuits, as well as the drama surrounding his channel, which led up to the current lawsuit he has filed. I am also aware, and as most of you will come to find out based on the actions I will describe in this video, that Acerthorn clearly has an assortment of mental health issues. And while that should be taken into consideration, there comes a point where mental illness is not a valid excuse for his actions. This is a man who is prone to aggression and violent outbursts, insane greed with intention to increase his monetary earnings at the expense of others, and most importantly, he's well aware of exactly what he's doing. Now that those disclaimers are out of the way, let's dive headfirst into this insane rabbit hole. When thinking of the misdeeds of Acerthorn, a majority will think of him constantly accusing people of doxing him, abusing his copyright, or a favorite of his, accusing people of having unclean hands. And while yes, dear Acer has done all of these things, that's only the tip of the iceberg, as he has an extended track record of attempting to exploit the legal system by filing LOLsuits whenever his sensitivity gets the best of him. LOLsuits are exactly what they sound like. Frivolous lawsuits that serve no purpose other than plaintiff mad. And by simply Googling the name Acerthorn and scrolling down a bit, a number of these documents can be found. This man throws lawsuits at people like confetti, as someone simply breathing is enough for Acerthorn to take them to court. How he's able to file so many lawsuits despite not having the income to afford such cost is by filing informal papyrus and pro se. In simpler terms, he, being someone with low income, is able to file lawsuits against others with little to no liability while representing himself in court. Not only does this make what he's doing much easier for him, but it makes the process for those he files against difficult. I'd love to dive into every court record on this guy, because some of this shit gets really comical. Unfortunately, due to the massive number of lawsuits he's involved himself in, I'm only going to read through the ones that I find to be the most relevant to his online character and his social relationships in order to showcase the kind of person we're dealing with here. Think of it as building a profile of sorts. Even though these records are public, I'll still be redacting Acerthorn's name and any other personal information that may be included. Instead, I will use his online name whenever said information comes up in the documents. Also, to reduce confusion and keep the flow of this video consistent, I will be reading the documents in chronological order. The first situation we'll be taking a look at is one of the more lighthearted ones on this list, and that's the time in 2011 when Acerthorn had the genius idea of trying to extort $500 billion from Microsoft. Yes, you heard that right, $500 billion. This turned so many heads that articles were made on this situation, Escapist magazine being one of the sites that picked up the story. An Xbox 360 owner is using a contractual technicality in the Xbox Live terms and conditions to press a legal claim that Microsoft owes him $500 billion. Acerthorn reckons that Microsoft owes him $500 billion. Take a moment to let that sink in if you need. And here's how he came to that rather remarkable conclusion. As an Xbox Live user, Acerthorn entered into a contract that was binding upon both him and Microsoft, which gave him the idea to, quote, unilaterally amend the terms of service. He submitted a notice of his amendments to Microsoft, giving the company 10 days to either accept the new terms or terminate his service. Microsoft neither responded nor terminated his subscription, which he argues means the company accepted the new contract by default. A couple weeks later, on May 18th, he contracted Microsoft again, this time with an offer to arbitrate a legal dispute, in which he claimed $500 billion in damages. The invitation also carried a forfeit victory clause, stating that Acerthorn would win the case by default if Microsoft failed to respond within 24 hours. As you probably guessed, the defendants did not accept the invitation to arbitrate within 24 hours of receiving it. Acerthorn wrote in a legal motion filed in a Seattle federal court. Therefore, I automatically won on May 19th of 2011, per the forfeit victory clause. Acerthorn does make the interesting point that he's merely using the same tactics that large companies often employ with their customers, changing the terms of the user agreement and taking the continued use of its service as acknowledgement of and agreement with the updated contract. I see a lot of friends and family who get pushed around and walked on, who have causes of action against them, but they choose not to pursue those causes of action. Lots of people are victims of torts. Few of them actually sue over them, but that doesn't mean that they can't, he told SeattlePI.com. I, on the other hand, will not let people push me around, just because I've already filed a bunch of claims already. It sounds not entirely insane until you get to the part where Acerthorn explains in his motion that he won't be offering anything to the court in paper because, quote, to do so would put an undue strain on my printer. Instead, he created a YouTube channel with screenshots of the changes he made to the Xbox TNC and the invitation to arbitration he emailed to Microsoft. The channel sadly has since been taken down. It's also far from Acerthorn's only lawsuit. He's filed more than a dozen within the past year, including similar far-fetched attempts at contract arbitration and claims of hiring discrimination because of his Asperger's syndrome. Acerthorn also made it clear that he didn't go out of his way to make sure his complaints showed up on Microsoft's radar. When I mail these documents to Microsoft, they won't do any legal division. I arranged for the mailings to be picked up by the employee that just collects regular mail, he says. It's quite possible that these employees won't understand the legal significance of these documents and know that they're required to respond. It's an interesting turnabout on the way companies manipulate user contracts as they see fit. I'm not sure how it's going to hold up as a legal strategy, and Acerthorn's willingness to admit that he's jerking the system around may have been meant ironically, but it still drains any sympathy I may have had for his quixotic ploy. Making a fair point is fine, but there's no need to be a dick about it. Microsoft has not yet commented on the matter. We'll put this story on hold for a bit, as it didn't get dealt with until 2 years later. Alas, Microsoft was not the only corporation to fall victim to Acerthorn's legal exploits, as in the same year he also filed a lawsuit against Walmart, which was already vaguely mentioned in the previous article. Acerthorn, plaintiff, versus Walmart Stores LLC defendant. Report and recommendation of the magistrate judge. Plaintiff Acerthorn filed this action pursuant to the provisions of the Rehabilitation Act, 29 U.S.C. 791 to 794. Plaintiff's motion to confirm arbitration, document 20, and defendant's motion for partial summary judgment, document 22, with respect to the arbitration claim, are before me for assurance of this report and recommendation. The parties have also filed a number of responses, supplements, and reply briefs on the issue, documents 25 to 32 and 34. Background. According to the allegations of the complaint, plaintiff, who has Asperger's syndrome, applied for a variety of jobs at Walmart during August of 2010. As a part of the application process, plaintiff was required to undergo a computerized assessment. Plaintiff maintains the assessment, in particular the questions regarding customer interaction, have a disparate impact on individuals with Asperger's syndrome. Plaintiff asserts that tactlessness and social awkwardness are signature traits of Asperger's. Plaintiff indicates he failed the assessment but would not have done so if the customer interaction questions were not considered. Plaintiff asserts that there are a number of jobs at Walmart that do not involve customer interaction that he was qualified for, including a janitor or overnight shelf stocker. On November 8, 2010, plaintiff sent an email to Walmart customer service which he maintains constitutes a formal offer to arbitrate the employment discrimination dispute. The language of the offer states in relevant part as follows. Notice to companies. My name is Acerthorn. I am sending a link to this webpage to various companies to put you on notice. If you contact me in any way, shape, or form, you hereby acknowledge that you have read, understand, and agree to be legally bound by the terms below. You hereby agree that you, as well as any principal or employer that you are acting on behalf of, will initially attempt to settle all legal disputes, even those not relating to this contract, by semi-binding arbitration using the services of www.net-arb.com. For you are bound, but I am not. Exhibit B, page 1, document 20. On November 17th, Walmart customer care responded. Thank you for your recent correspondence. Your message has reached the office that exclusively assists with customer-related matters. In order to obtain the best assistance with your associate/open door issue, we would recommend contacting your market manager. ID at page 2. On November 21st, plaintiff responded, apparently you weren't aware of this, so here it is. On November 8th, 2010, I sent you a formal contract offer via email. The email stated that if you initiate communications with me, or if I initiate communications with you, and you entertain said attempt to communicate, you are bound by that contract. You accepted that offer on November 11th, 2010 when I purchased a gallon of milk from you, using a paper check. This check had my name and street address on it, so you knew who I was. Also, your employees asked me to see my ID, and I showed them my driver's license, so you had every opportunity to know who I was then. Here's the contract that you entered into with me. And then he sends a link to a MySpace blog. So now we must hold all legal disputes via arbitration, whether you like it or not. ID at page 3. On November 24th, Walmart sent plaintiff an email identical to the one on November 17th, ID at page 4. Thereafter, plaintiff registered with Net-Arb, an online arbitration service, ID at page 5. Net-Arb sent an email to Walmart regarding plaintiff's registration and his desire to arbitrate an employment dispute, ID at pages 5 through 6. According to plaintiff, since Walmart did not accept the arbitration invitation within 24 hours of receiving it, he automatically wins regardless of the merits of the case and is entitled to an award of $600 billion. Document 20 at pages 2 through 3. Discussion. Plaintiff has moved for enforcement of the arbitration agreement. Walmart maintains there is no cognizable claim because there was no agreement to arbitrate. Under the Federal Arbitration Act, a dispute must be submitted to arbitration if there is a valid agreement to arbitrate, and the dispute falls within the scope of that agreement. However, a party who has not agreed to arbitrate a dispute cannot be forced to do so. State contract law governs the threshold question of whether an enforceable arbitration agreement exists between litigants. Under state law, a contract must include these essential elements. 1. Competent parties. 2. Subject matter. 3. Legal consideration. 4. Mutual agreement, and 5. Mutual obligations. In this case, plaintiff maintains Walmart accepted the contract by its act of replying to his email. Unilateral contracts commonly exist where a reward is offered, a contest is involved, or where changes are made and disseminated in an employee manual. See Aon Risk Services Inc. versus Meaters. In such cases, the offeree does not accept the offer by express agreement, but by his performance. Even though he had not directly communicated his acceptance, a contract is formed as the result of his performance. The performance also constitutes a consideration for the contract. Whether a proposal is meant to be an offer for a unilateral contract is determined by the outward manifestations of the parties and not by their subjective intentions. In this case, the terms of the emails do not suggest the existence of a contract. The emails from the plaintiff are self-serving documents that did not form the basis for any conduct or performance on Walmart's part. A unilateral contract is a promise in exchange for an act. Crawford v. General Contract Corporation. In this case, Walmart performed no act. It merely replied to the 2 emails by directing the plaintiff to the correct department. It performed no service and the plaintiff made no promise. See Restatement 2nd of Contracts 71, 1-2, 2010. To constitute consideration, a performance or a return promise must be bargained for. A performance or return promise is bargained for if it is sought out by the promisor in exchange for his promise and is given by the promisee in exchange for that promise. Jesus fucking Christ, that was a tongue twister. Conclusion. For the reasons stated, I recommend that the plaintiff's motion to confirm arbitration, document 20, be denied, and Walmart's motion for summary judgment as to the arbitration claim, document 22, be granted. The parties have 14 days from receipt of this report and recommendation in which to file written objections pursuant to 28 U.S.C. 636b(1). The failure to file timely objections may result in waiver of the right to appeal questions of fact. The parties are reminded that objections must be both timely and specific to trigger de novo review by the district court. If you thought that based on the 2 cases I just went over gave Acerthorn a hint that going after large corporations was a bad idea, then you're wrong, as in the same year Acerthorn decided to sue Google. Introduction. On August 8, 2011, plaintiff filed in forma pauperis a motion to confirm arbitration award against defendant Google Incorporated in the amount of $500 billion. In support of his motion, plaintiff invokes the Federal Arbitration Act, which provides that parties may apply to a federal court for confirmation of an arbitration award if the parties in their agreement have agreed that a judgment of the court shall be entered upon the award made pursuant to the arbitration. Nowhere, however, does plaintiff allege that there actually was an arbitration and that he actually obtained an award made pursuant to an arbitration. Based on plaintiff's submissions and the relevant law, the court denies plaintiff's motion to confirm and dismisses this case with prejudice as frivolous. Background. Plaintiff alleges that he had 2 accounts, called channels, with YouTube Inc., a company that is owned and controlled by Google. Plaintiff argues that, under YouTube's terms of service, the terms may be unilaterally modified at any time, and that if the other party does not wish to accept the terms, they may sever the contractual relationship. Plaintiff alleges that on March 22, 2011, he attempted to unilaterally change the terms of the YouTube agreement by emailing YouTube's general service email address new terms, which included the names of the parties, the method of accepting the amendment, and an agreement, quote, to hold all legal disputes between the parties, even those not related to this contract, to binding arbitration, unquote. Plaintiff's email included what he refers to as forfeit victory clause, which states, if you do not accept my invitation to arbitrate within 24 hours of receiving it, I automatically win the relief requested, regardless of the merits. No actual arbitration award need be entered. I simply win automatically without having to go to arbitration. However, this will only apply to me. Plaintiff also alleges that after defendant failed to delete his YouTube accounts within the 30-day time limit they were allotted, he sent defendant a second email on May 2, 2011, which was an invitation to arbitrate a legal dispute for compensatory damages of $500 billion. Plaintiff's second email specifically states, Dear Google, here, print this out, fill it out, scan it, and send it back to me by this time tomorrow, or else you lose automatically, via the forfeit victory clause in our agreement. Plaintiff argues that, because defendant failed to accept the invitation to arbitrate, the forfeit victory clause in his first email compels this court to confirm an arbitration award in the amount of $500 billion. On August 31, 2011, Magistrate Judge Graywall ordered that the case be reassigned to a district judge because the parties did not consent to proceed before a magistrate judge. Order that case be reassigned and recommendation that case be dismissed. August 31st order. Judge Graywall noted in his August 31st order that plaintiff had not filed a complaint, but instead filed a motion to confirm arbitration award. Finding that the motion was frivolous, Judge Graywall recommended dismissal on the grounds that 1. The Federal Arbitration Act, which applies to an award made pursuant to the arbitration, is inapplicable as a matter of law because the instant case involves no arbitration award, and 2. Plaintiff fails to allege any facts that even remotely suggest that YouTube or Google took up plaintiff's invitation to enter into an agreement, let alone entered into arbitration over it. Plaintiff filed an objection to recommendation of dismissal, a supplement to objection to recommendation of dismissal, and an additional supplement to object to recommendation of dismissal on September 6, 2011. On September 8, 2011, plaintiff also filed a third supplement to object to recommendation of dismissal. Absent the consent of all parties, a magistrate judge does not have authority to make dispositive rulings. In the instant case, the parties did not consent to a magistrate judge, whereas here, a party to an action objects to a magistrate judge's findings or recommendations. A judge of the federal district court shall make a de novo determination pursuant to 28 U.S.C. Thus, the court will review Magistrate Judge Graywall's order de novo. Under the informa pauperis statute, the court must dismiss an informa pauperis action if the court finds that the action fails to state a claim on which relief may be granted, or that the action is frivolous or malicious. A complaint, containing as it does both factual allegations and legal conclusions, is frivolous where it lacks an arguable basis either in law or in fact. Definition of frivolous embraces not only the arguable legal conclusion but also the fanciful factual allegation. As the United States Supreme Court has explained, the informa pauperis statute is designed largely to discourage the filing of and waste of judicial and private resources upon baseless lawsuits that paying litigants generally do not initiate because of the costs of bringing suit. It affords judges not only the authority to dismiss a claim based on an indisputably meritless legal theory, but also the unusual power to pierce the veil of the complaint's factual allegations and dismiss those claims whose factual contentions are clearly baseless. Dismissals on these grounds are often made sua sponte prior to the issuance of process, so as to spare prospective defendants the inconvenience and expense of answering such complaints. Analysis. The court reviews Magistrate Judge Graywall's recommendations contained in his August 31st order de novo. The court construes plaintiff's motion to confirm as a complaint, subject to the same standards of procedure and review. A. Plaintiff's complaint fails to state a claim under the Federal Arbitration Act. Invoking the Federal Arbitration Act, plaintiff argues that this court does not have the authority to deny this motion to confirm an arbitration award sua sponte. The Federal Arbitration Act provides that parties may apply to a court for confirmation of an arbitration award if the parties in their agreement have agreed that a judgment of the court shall be entered upon the award made pursuant to the arbitration. The Federal Arbitration Act does not specify procedures to be used in conducting an arbitration, and in general, arbitrations do not require the same procedural protections as judicial proceedings as seen in Sunshine Mining Company versus United Steelworkers of America. However, as the Ninth Circuit recognized in that case, the arbitrator must grant the parties a fundamental fair hearing that meets the minimal requirements of fairness, adequate notice, a hearing on the evidence, and an impartial decision by the arbitrator, thus absent the existence of an award made pursuant to the arbitration, wherein the arbitrator must grant parties a fundamentally fair hearing, is inapplicable as a matter of law to compel the court's confirmation of an alleged award. As Judge Graywall noted, plaintiff does not allege that he obtained an award pursuant to arbitration, nor does plaintiff allege the existence of an arbitration proceeding, much less one in which the arbitrator granted the parties a fundamentally fair hearing. See also Sunshine Mining Company. Instead, plaintiff argues that he is entitled to what he calls an arbitration award of $500 billion, obtained as a result of defendant's failure to respond to an invitation to arbitrate, emailed to defendant on May 2, 2011. Since plaintiff did not allege the existence of an award pursuant to arbitration nor the existence of any arbitration proceeding, this court finds that 9 U.S.C. 9 is inapplicable as a matter of law. In his objection to recommendation of dismissal, plaintiff states there is an arbitration award, and cites to a number of cases involving judicial enforcement of arbitration awards of default judgment, motions 2 through 3. Plaintiff's authorities are inapposite. Even though these cases involve judicial enforcement of default judgments entered in arbitration proceedings, in all but one case, the courts considered whether to enforce awards made pursuant to actual arbitrations. Here, no arbitrator was called, and there was no actual arbitration. That is to say, no arbitrator or arbitration panel actually awarded a judgment. Thus, there has been no arbitration proceeding and no award made pursuant to an arbitration. Emphasis added. It is not sufficient for the plaintiff simply to assert, without factual allegations in support, that there is an arbitration award. The court is not required to accept as true. Allegations are merely conclusory, unwarranted deductions of fact, or unreasonable inferences. Moreover, plaintiff cites no authority to support construing plaintiff's so-called forfeit victory as an award made pursuant to arbitration. Thus, Section 9 does not compel this court to grant plaintiff's motion to confirm. Accordingly, plaintiff fails to state a claim on which relief may be granted, and the court must dismiss the action under 28 U.S.C. B. Plaintiff's motion is frivolous. In an action brought in forma pauperis, courts have authority to sua sponte dismiss an action as frivolous, if it lacks an arguable basis either in law or in fact. Importantly, in an action in forma pauperis, courts have not only the authority to dismiss a claim based on an indisputably meritless legal theory, but also the unusual power to pierce the veil of the complaint's factual allegations and dismiss those claims whose factual contentions are clearly baseless. As stated above, plaintiff's claim is based on an indisputably meritless legal theory. Additionally, plaintiff's factual assertion is that there is an arbitration award conflicts with his allegation that, under his forfeiture victory clause, no actual arbitration award need be entered. I simply win automatically without having to go to arbitration. It is fundamentally contradictory for plaintiff to assert the existence of an arbitration award on the basis of a contract clause that states that no arbitration proceeding is to take place and no award need be entered. Plaintiff's factual contention that there is an arbitration award, i.e., an award pursuant to arbitration and subject to the FAA, is therefore clearly baseless, frivolous, and subject to dismissal sua sponte by this court. Conclusion. Because plaintiff has stated an indisputably meritless legal theory, and because plaintiff's factual contentions are clearly baseless, the court hereby denies plaintiff's motion to confirm arbitration award and dismisses with prejudice the case for failure to state a claim and as frivolous. The clerk shall close this file. It is so ordered. October 27th, 2011. Already there's a pattern in how Acerthorn approaches situations when making legal threats. Not only do all these cases involve Acerthorn demanding ungodly amounts of money only to end in either nothing happening or a motion to dismiss, but he will make massive reaches to try and find or create loopholes in contracts or terms of service to help solidify some sort of legitimacy to an already ridiculous lawsuit of his. Acerthorn also attempted suing both Full Sail University and the University of Arkansas. However, these two cases were quickly dismissed due to lack of jurisdiction. In 2012, he sued the University of Arkansas another time, which actually amounted to more than the previous filing, and some of the stuff in this document is, well, it's definitely something. Memorandum Opinion. On December 3rd through 4th, 2012, the captioned matter came on for trial to the court. Plaintiff appeared and represented himself. Defendants appeared by their representative Dr. Monica Holland and represented by counsel. The court received documentary evidence and heard testimony and the arguments of counsel, and now makes for the following findings of fact and conclusions of law. Procedural history. Plaintiff Acerthorn contends that the University of Arkansas, UA, discriminated against him in violation of Section 504 of the Rehabilitation Act of 1973 by failing in 2010 to allow him to re-enroll as a student after he was banned from campus in 2007. Acerthorn contends that he has a disability, Asperger's syndrome, and that UA made no attempt to accommodate this disability. He seeks money damages and injunctive relief. Acerthorn also asserted claims that his First Amendment rights were violated by UA Chancellor David Gearhart, and that he was subjected to employment discrimination by UA. These claims were dismissed before trial as lacking merit, and will not be addressed in this opinion. Findings of fact. Acerthorn enrolled in UA as an undergraduate student in August 2007. In connection with his enrollment, on August 14, 2007, he registered with UA's Center for Education Access, CEA, which facilitates the college experience for students with disabilities. In his registration form, Acerthorn stated, "I have Asperger's, a mild form of autism, making it difficult to find people who put up with me. Also, I am tactless and can accidentally smart off to authorities." Acerthorn indicated that the account accommodation he sought was help negotiating my tactlessness with my professors. A summary of Acerthorn's registration meeting stated, requested accommodations. None at this time, but he feels he may need services in the future. On September 19, 2007, Acerthorn returned to the CEA because he had lost his room key and his cell phone, and had problems with the bookstore and with his bank account. At that time, the CEA had not received documentation of Acerthorn's disability. The CEA received documentation regarding Acerthorn's disability from Vista Health Counseling Center in Acerthorn's hometown on September 24, 2007. The Vista Health chart reflects diagnoses of intermittent explosive disorder, IED, Asperger's disorder, and panic disorder without agoraphobia. The most recent chart note, dated April 10, 2007, reported that Acerthorn's mother said he was frequently verbally aggressive and sometimes physically aggressive. This note also reported that Acerthorn had made no progress towards his treatment plan goals and blamed his anger on others. Other chart notes reflect that Acerthorn tended to externalize blame and was unable to consider the feelings of others. Anne Janarone, director of the CEA, testified that Asperger's syndrome is a high-functioning form of autism, characterized by social awkwardness and challenges with social interaction, but not by violence. In her experience, students with Asperger's syndrome do not make threats or use profanity. IED is characterized by explosive outbursts of anger and both verbal and physical aggression, usually not premeditated. Panic disorder is characterized by extreme fear and tremendous anxiety. Based on the Vista Health documentation, on September 24, 2007, the CEA accommodated Acerthorn with preferential seating at the front of his class and permission to use a laptop computer in class with the internet disabled. Acerthorn did not request that the CEA approve any accommodations relating to the use of profanity or threats of violence. However, even if he had, Janarone testified that such conduct rises to the level of a conduct violation under the Code of Student Life, and it would not be reasonable to accommodate it. She testified that UA does not provide unreasonable accommodations. Acerthorn met with Janarone on October 11, 2007 regarding a lost book and problems with following his instructors in class. Janarone approved an additional accommodation, permission to record class lectures. On October 12, 2007, an incident occurred in Acerthorn's dormitory. Debbie Hudson, who worked in the front desk and handed out mail, had been asked to deliver mail to several other dorms because the dorms were short-handed. Hudson put up a sign saying she would be back at 3 p.m., but she did not return until 3:15 p.m. Upon her return, Acerthorn confronted Hudson. He was very upset, cursing, raving, and slinging his arms, saying, "You said you'd be back at 3, and you weren't. I need my package, and I need it now." While this was not Hudson's first encounter with an enraged, yelling, cursing Acerthorn, he seemed unusually violent to her that day, so much so that she filled out an information report. Hudson testified that this was the first information report that she has ever made in some 23 years at UA. She wrote in it that, "I thought I should write this report because I think Acerthorn would be a danger to students and myself in this hall." Acerthorn later apologized to Hudson, saying, "I would never hit you because if I did, I would be suspended from school." On November 14, 2007, Acerthorn went to the treasurer's office, upset about a charge to his financial account. The situation was described by Joanne Pepper, Financial Systems Coordinator and Director of Student Accounts. She testified that Acerthorn was upset, yelling, cursing, and ranting. The incident was so disturbing that Pepper reported it to Dr. Daniel Pugh, Dean of Students, who instructed the treasurer's office not to deal with Acerthorn any further, but to have him deal directly with Dr. Pugh's office. As a result of the incidents with Hudson and with the treasurer's office, Acerthorn came to the attention of Dr. Monica Holland, who was at the time director of the Office of Community Standards and Student Ethics, OCSSE, the office charged with enforcing the Code of Student Life. Dr. Holland summoned Acerthorn to her office and charged him with a violation of Section IB8 of the Code of Student Life, disorderly conduct, including but not limited to verbal abuse or inappropriate behavior, or any activity or behavior prohibited by ARC Code Ann. Acerthorn elected to have Dr. Holland conduct an immediate administrative hearing. She did so and found him responsible for the charged violation. She placed Acerthorn on conduct probation for 1 year with the prospect of suspension if there were any more violations of the Code of Student Life. She also required Acerthorn to write a letter of apology to the treasurer's office, to write one to Hudson unless it could be confirmed that, as he stated, he had already apologized to her, and to meet with CEA personnel to develop a plan to minimize future occurrences of the behaviors that had resulted in his referral to OCCSE. Acerthorn wrote a letter of apology to the Treasurer's office as instructed, but added a PS. I would like to point out, as calmly as I can, may I add, that I do not appreciate being defamed like I was. Claiming that I was accusing individuals of conspiring this problem and that I did not calm down after the waiver was presented to me are nothing but bald-faced lies. I hope you know that that is libel and is illegal. On November 28, 2007, Acerthorn returned to the Treasurer's office. He demanded to know who had sent the information about him to Dr. Holland, saying it contained lies and threatening to file charges of slander against the Treasurer's office. On December 3, 2007, Dr. Holland called Acerthorn into her office to discuss his conduct upon returning to the Treasurer's office, as well as a report of his using profane language with a resident assistant. No charges under the Code of Student Life were brought against Acerthorn as a result of this conduct, but during the meeting, Acerthorn told Dr. Holland of a plan he had for injuring his father. As reported by Dr. Holland in a memo to Acerthorn's file, Acerthorn indicated he plans to have his father in his room, at which point he would cut his father's forehead and take his blood to write a letter of forgiveness. Acerthorn indicated he planned to have the occurrence videotaped and posted on the internet website YouTube. Acerthorn indicated that thinking of the pain his father would be in and the screams he would produce gave him chills. Acerthorn proceeded to make the physical motion of a person who had the chills while making this statement. Acerthorn was asked how often he thought of this plan, in which he replied a response to the effect of, "I practically jerk off to it daily." This meeting so disturbed Dr. Holland that she spoke with her supervisor. They decided to contact Janarone and Chad Parsons, counselor in resident at Acerthorn's dorm, and meet as a group with Acerthorn to try and help him and also to determine if he had the ability to carry out the threat against his father. On December 4th, 2007, Acerthorn met with Janarone to discuss the amount of support he had in place to manage his disability. During this meeting, Dr. Holland called Janarone to set up the meeting with Acerthorn, Janarone, and Parsons. When the meeting was suggested to Acerthorn, he abruptly left Janarone's office. On December 5th, 2007, Acerthorn went to the Pat Walker Health Center, dubbed Health Center, to obtain a renewal of some prescriptions. He had not run out of his medication at this time, but he was running low. Because he was half an hour late for his appointment, staff at the health center told him he would have to reschedule. Acerthorn became angry and extremely distraught. He went to the UA Ombuds office, where he talked to Susan Thies, whose job it was to attempt a neutral resolution of conflicts. During their meeting, Acerthorn told Thies that if he did not get his medications, there would be another Virginia Tech incident. This was about 8 months after a student at Virginia Tech shot and killed numerous innocent bystanders, an incident that made national headlines. Thies testified that she almost pushed her panic button while talking to Acerthorn. Thies walked with Acerthorn to counseling and psychological services, dubbed CAPS, and arranged for him to receive his prescriptions. During the walk, Acerthorn repeated his assertion about another Virginia Tech incident and did not appear to be in control of what he was saying or doing. Acerthorn's conduct so disturbed Thies that, although her work by nature confidential, she filled out an OCCSE referral form about the situation because she considered Acerthorn a significant threat. As a result of Acerthorn's statement about a Virginia Tech incident, Dr. Holland decided to place him on interim suspension. Section IE2 of the Code of Student Life defines interim suspension as an action requiring that a student immediately leave the campus and university property. It suspends the student's participation in any classes or any other university activities. Before notifying Acerthorn of the interim suspension, Dr. Holland arranged for his mother to come to the campus to pick him up. She also arranged for Lieutenant Vance Rice of UA Police Department to be present for security purposes. Dr. Holland verbally informed Acerthorn of his interim suspension and the reasons for it. She also documented the interim suspension in a letter to Acerthorn stating that his Virginia Tech incident comments and his plan to injure his father violated sections IB1, IB8, and IB35 of the Code of Student Life. Terms of the interim suspension were that Acerthorn was not allowed to be in any UA building, dorm, apartment, or campus event, and must participate in the formal review process under the student judicial system. Acerthorn was so distraught about being suspended that, before leaving campus, he threatened to commit suicide, threatened to attack Lieutenant Rice, and stated that a Virginia Tech incident was still a possibility. Dr. Holland, Acerthorn's mother, and Lieutenant Rice eventually persuaded Acerthorn to check into a hospital for mental evaluation. It appears that the most effective form of persuasion was Lieutenant Rice's statement that if Acerthorn did not voluntarily check in, he would be arrested and held so that Lieutenant Rice could seek an involuntary commitment. A formal review of Acerthorn's interim suspension took place on January 10, 2008 before a board of the All-University Judiciary, AUJ. Acerthorn testified, as did his mother, Parsons Thice, and Dr. Holland. Acerthorn and the board members were allowed to question each witness until they had explored the matter as fully as they desired. During his testimony, Acerthorn agreed that asking UA to look the other way would not be a reasonable accommodation for statements such as his Virginia Tech incident comments, and acknowledged that he had come to understand that cursing was not only offensive to some people, but could be seen as a threat. The board found Acerthorn responsible for the behaviors charged, and concluded that interim suspension was the appropriate response to his Virginia Tech incident statements. It determined that he would be allowed to re-enroll in fall of 2008 if he fulfilled the following conditions. During the period of suspension, he had to obtain mental health care from a psychiatrist addressing the behaviors that resulted in his suspension and his anger management issues, and he had to sign a waiver allowing OCSSE to confirm his participation in these counseling sessions. Upon re-enrollment, he would be required to continue to participate in counseling. The duration of counseling was to be at the discretion of the mental health professional. Finally, a 1-year conduct probation would be imposed upon re-enrollment. Although an avenue of administrative appeal existed, Acerthorn did not appeal the decision of the AUJ. During the spring semester of 2008, Acerthorn lived off campus and sought mental health treatment from Carla Brown, a licensed social worker at Ozark Guidance Center. Brown diagnosed Acerthorn with Asperger's disorder and relational problems related to mental health diagnosis. By the time Acerthorn stopped coming to her for counseling, Brown had added intermittent explosive disorder to the list of diagnoses. While Acerthorn initially stated to Brown that he would do anything to get back into school, Brown testified that Acerthorn put forth only minimal effort during the course of treatment, made only minimal progress, and left at the end of April 2008 to move home to his hometown. According to Brown, Acerthorn wanted the others to adjust their behavior rather than making the effort to change his own, and tended to blame others for his problems rather than taking responsibility for them himself. He repeatedly verbalized thoughts of revenge, including, on one occasion, fantasies of kidnapping, torturing, and killing people who angered him. Pursuant to releases authorizing her to convey information about Acerthorn's mental health to UA personnel, Brown told Dr. Holland in early May 2008 that in her professional opinion, it would not be safe for Acerthorn to return to campus. On December 21st, 2009, Acerthorn emailed Dr. Holland asking if he could come back, and if not, how to appeal that decision. Dr. Holland responded that Acerthorn had not met the conditions of the AUJ for re-enrollment, and that he had forfeited his right to appeal by not timely submitting an appeal. On June 13, 2010, Acerthorn sent an email to Chancellor Gearhart, making demands related to re-enrollment. Judy Schwab, Associate Vice Chancellor for Administration, received the email on a website she and the Chancellor both monitor. Schwab described the email not only as threatening, but as off the continuum of rage and anger. Although it was after business hours when she received the email, Schwab was sufficiently concerned to call Chancellor Gearhart at home to alert him about it. The subject line of this email stated, "Your hair's a breath away from getting sued out your ass." The content of the email is instructive in understanding the situation that presented itself at the time, and is repeated here verbatim. Listen up, you fucking maggot. For the purposes of this email, I am not talking to the University of Arkansas. I am talking to David Gearhart in your individual capacity. Remember, since I am addressing not the UA Chancellor but David Gearhart, this means that you do not have sovereign immunity. On January 2008, I was expelled because your fucking inbred crackpot employees could not be bothered to accommodate my disability. They say I made a terroristic threat. This is fucking bullshit. You didn't fucking threaten anyone. You took it that way. So listen up, you fucking retard. You fucking inbred cocksucking piece of shit. I'm not asking you, and I sure as hell am not asking you kindly. You have 16 business hours. You have until 5 p.m. this Tuesday evening to do the following. 1. Override the student accounts office. That is why I am talking to you, because if anyone has the authority to do it, it's you. 2. Remove my suspension. Make it so that officially I was never kicked out against my will in the first place. I withdrew on my own. 3. Allow me to readmit myself to the University of Arkansas on the spot. No applications, no fucking interviews, no jack shit. And 4. Send me an email telling me that the above 3 have been accomplished. All of them must be completed by Tuesday, June 15th, 2010 at 5 p.m. CT. If they are not, I will sue you in your individual capacity and collect $50,000 in punitive damages from you. Thank you and go to hell. Sincerely, Acerthorn. On June 14, 2010, a threat assessment team was convened to determine how to respond to this email. It was determined that Acerthorn should be placed under a criminal trespass warning for a year, during which he would not be allowed on UA property. Lieutenant Rice advised Acerthorn by email that he was not to make direct contact with any member of administration, that he should contact Lieutenant Rice and make arrangements if he needs to meet with anyone at UA, and that his status would be re-evaluated in 1 year. Acerthorn testified that UA should have accommodated him with access to his medication and patients. He contended that UA should have given him the benefit of the doubt, as long as it was possible that he did not mean to carry out his Virginia Tech incident threat. The evidence supports a finding that Dr. Holland and the AUJ board reasonably believed that Acerthorn's threats of violence had to be taken seriously. The Vista Health records available to the CEA included a note that Acerthorn's mother had told Acerthorn's counselor that Acerthorn could be both physically and verbally aggressive. Hudson, Pepper, and Thice had made written reports about Acerthorn's disturbing behavior. Dr. Holland had access to this information when she heard Acerthorn verbalize his gruesome plan regarding his father and his Virginia Tech incident comments. Conclusions of law. UA contends that Acerthorn's case should be dismissed because he failed to exhaust administrative remedies when he did not appeal the decision of the AUJ. The court finds this contention without merit. UA did not plead failure to exhaust as an affirmative defense in its answer. Generally speaking, failure to plead an affirmative defense results in a waiver of that defense. While the Eighth Circuit has recognized that a trial court may exercise discretion to allow the defense to be untimely pled if it does not result in unfair surprise, UA never sought to amend its answer, nor was the matter brought to the court's attention until shortly before trial. Under these circumstances, the court finds that UA has waived this defense. To make out a prima facie case on his Rehabilitation Act claim, Acerthorn must show the following. A. That he is a person with a disability as defined by statute. B. That he is otherwise qualified for the benefit in question, enrollment at UA. C. That he was excluded from the benefit due to discrimination based on his disability. And D. That the program or activity from which he was excluded receives federal financial assistance. Disability, for purposes of the Rehabilitation Act, has the meaning given in 42 U.S.C. It includes a person with a physical or mental impairment that substantially limits one or more major life activities, a person with a record of such impairment, and a person regarding as having such an impairment. Major life activities include learning, thinking, communicating, and working. Defendant admitted in responses to requests for admission that Acerthorn was eligible for accommodations based on the disability of Asperger's syndrome. Thus, element A is not in dispute. Acerthorn presented a web shot of a UA description of available financial aid, including statements relating to application for federal student aid, and this was admitted without objection. It appears, therefore, that the element D is also undisputed. A person is otherwise qualified under the Rehabilitation Act if, with reasonable accommodations, he can perform the essential functions of the position in question without endangering the health and safety of the individual or others. Failing to make reasonable accommodations is a form of disability discrimination. Acerthorn has the initial burden of proving that he requested reasonable accommodations from UA and that those accommodations would render him otherwise qualified. He need not have used any particular words to request accommodations, but must have said enough to invoke the interactive process, whereby he and UA would have worked out what accommodations were appropriate for what disability. Acerthorn failed to establish that he requested reasonable accommodations applicable to the reason for his suspension. The evidence shows that when he registered with the CEA as having Asperger's syndrome, the only accommodation he mentioned was help negotiating my tactlessness with my professors. His statements that if he did not get his medications refilled, there would be another Virginia Tech incident are on a different order of magnitude than mere tactlessness. They could reasonably be interpreted as threats to the safety of the entire UA community, and in fact were so perceived. Moreover, Acerthorn failed to show that the accommodations he requested after having made the Virginia Tech incident comments patience and understanding, giving him the benefit of the doubt, not taking his words as threatening unless he really meant them that way, giving him a second chance, or reason reasonable. Janarone testified that it would be unreasonable to accommodate behavior that rises to the level of a violation of the Code of Student Life, such as threats and profanity. The legal touchstone for reasonable accommodation supports this position. An accommodation is not reasonable if it imposes undue financial and administrative burdens on an institution. For UA officials to have adopted a wait-and-see attitude in the face of Acerthorn's Virginia Tech incident comments would have burdened UA with the risk of all the financial, administrative, and human toll that another Virginia Tech incident would have carried with it had they made the wrong decision. It cannot be seriously argued that such would be reasonable. Acerthorn also failed to establish that he was excluded from the benefit of UA enrollment due to discrimination based on his disability. The evidence shows that accommodations appropriate to Asperger's syndrome were afforded to Acerthorn, and that he was not suspended for tactlessness or the social awkwardness and challenges with social interaction that characterize Asperger's syndrome. He was suspended for making threats, which is not a characteristic of Asperger's syndrome. Not only did Acerthorn fail to establish a prima facie case of discrimination, UA succeeded in establishing its affirmative defense that Acerthorn constituted a direct threat to the UA community as to which it had the burden of proof. The criteria to be used in assessing whether a student presents a direct threat are drawn from School Board of Nassau County, Florida versus Arline, wherein the court said that the Rehabilitation Act has goals of protecting handicapped individuals from discrimination, while giving appropriate weight to such legitimate concerns of grantees as avoiding exposing others to significant health and safety risks. Factors to consider in the evaluation of risk under Arline include A. the nature of the risk, B. the duration of the risk, C. the severity of the risk, and D. the probability of the risk. When the Arline factors are applied to the facts of this case, they lead ineluctably to the conclusion that UA officials properly evaluated Acerthorn as a direct threat to UA on December 5th, 2007, when he made repeated statements that if he did not get his medications refilled, there could be another Virginia Tech incident. A. The nature of the risk. Acerthorn's statements about a Virginia Tech incident went far beyond the tactlessness and smarting off he noted when registering with the CEA. Only a few months before, a student had shot and killed a large number of people on the campus of Virginia Tech, a highly publicized event that shocked the nation, and especially those on college campuses. UA was not required to prove that a threat was actually made and intended by Acerthorn, but rather that those who heard his statements reasonably believed that a threat was made. Based on Acerthorn's history at UA, Dr. Holland and the AJU could reasonably have believed that Acerthorn might do the same thing. B. The duration of the risk. By December 5th, 2007, Acerthorn had been a student at UA for about 4 months. In that short period of time, he had significant difficulties in his interactions with dorm staff and the treasurer's office staff. Dr. Holland, who made the decision to suspend Acerthorn, knew about these difficulties, and it was reasonable for her to believe that the December 5th, 2007 incident was not an isolated one, but rather a pattern that has existed from Acerthorn's enrollment and was not likely to improve without significant intervention. Thus, the duration of the risk was indefinite. C. The severity of the risk. The risk in this case was severe. Acerthorn's statements implicated the safety, indeed, the lives of students, faculty, and staff at UA. No reasonable administrator could afford to overlook them. And D. The probability of the risk. Given Acerthorn's history since matriculation, reflecting a pattern of repeatedly becoming enraged over what others would perceive merely as minor annoyances, it was reasonable for Dr. Holland and later the AUJ to believe that there was a significant probability that Acerthorn would carry out his threats of another Virginia Tech incident. Finally, the court is not persuaded that there was any violation of law when UA decided not to allow Acerthorn to re-enroll following his profanity-filled email to Chancellor Gearhart. In addition to the fact that Acerthorn still had not satisfied the conditions of re-enrollment established by the AUJ, there was the threatening tone of the email itself. While Acerthorn argued at trial that the only threat to be found in the email was the threat to sue Chancellor Gearhart, the court does not agree. The email is extremely profane, and Acerthorn admitted at the AUJ hearing, long before he sent the email, that he knew profanity could be perceived as threatening. The tone of the email is intensely malicious. The email is couched in terms of demands that must be met within hours. The threat to sue is obviously coercive in nature. When viewed in light of Acerthorn's past history at UA and his mental health treatment records, the email was clearly threatening, and the court finds that it was reasonable for UA to conclude that Acerthorn should not be allowed back in school or even on campus. Having concluded that Dr. Holland's interim suspension was reasonable, that the interim suspension of the AUJ was reasonable, and that the criminal trespass warning in 2010 was reasonable, it follows that Acerthorn's claim that UA violated the Rehabilitation Act is without merit. There is, therefore, no need to address the issues of damages or injunctive relief. His claims will be denied and dismissed with prejudice, and a separate judgment to this effect will be entered contemporaneously herewith. It is so ordered this 28th day of December 2012. Jim Larry Henderson, United States District Judge. This document is honestly the best summary I could gather of Acerthorn's overall character, and it's very telling that the adults at the university expressed a level of fear when interacting with him, let alone how he treated the people there to begin with. It also showcases some of the behavior that Acerthorn continues to exhibit to this day. Sadly, the document is also accurate about his mistreatment of his parents. But before we dive into that darker portion of the video, let's take a quick intermission and look back at the lawsuit Acerthorn filed against Microsoft. At the beginning of the video, I read the article describing what was happening and why Acerthorn was suing them, but it wasn't until a year after the University of Arkansas lawsuit that the court documents were recorded. Acerthorn appeals pro se from the district court's judgment dismissing his action to enforce an arbitration under the Federal Arbitration Act. We review de novo a dismissal for failure to state a claim, and for an abuse of discretion, the denial of reconsideration. We affirm. The district court properly dismissed Acerthorn's action because Acerthorn's unilateral amendments to an existing contract with Microsoft Corporation did not give rise to a valid agreement to arbitrate between the parties. The district court did not abuse its discretion in denying reconsideration because Acerthorn failed to establish grounds for such relief. Acerthorn's contentions regarding defendants' alleged control over the district court are unpersuasive. We do not address arguments allegedly incorporated by a reference on appeal. Arguments not expressly discussed in the opening brief are deemed waived. Acerthorn's motion to file a supplemental brief filed on March 12, 2012 is denied as moot, and his motion for a stay is denied. Acerthorn's motion to clarify this court's April 9, 2012 order, filed on April 9, 2012, is granted in part, and the clerk is directed to file an amended order clarifying that its March 20, 2012 order, not the June 30, 2009 order, is vacated. Acerthorn's motion to not schedule oral argument, or in the alternative for leave to participate in oral argument by telephone, or in the alternative for appointment of counsel for oral argument, filed on June 16, 2012, is denied. Microsoft's motion to file late excerpts of record filed on March 19, 2013 is granted. Affirmed. Yep, nothing new. Federal Arbitration Act, attempts to amend contract, motion to dismiss. It's like a cycle with this guy in court. Fast forward a bunch of other pointless lawsuits against businesses and companies, as well as a number of appeals to sue the University of Arkansas once again, and Acerthorn filed a lawsuit against his own mother. The document here is one of two that were recorded for this case. I'm reading the second one instead of the first one, as it includes more details that give a better description of what happened. Per curiam. Acerthorn appeals following the district court's pre-service dismissal of his pro se action, in which he alleged that defendants, his parents, improperly listed him as a dependent on their tax returns. In dismissing Acerthorn's complaint, the district court concluded that Acerthorn has a history of frivolous litigation and had abused the privilege of proceeding in forma pauperis. The court thus imposed restrictions on Acerthorn's future filings. Specifically, the court limited the number of cases that Acerthorn would file in the Western District of Arkansas to no more than one case every 3 months, and only upon payment of a $50 bond, refunded if the complaint was adjudged not frivolous. The court added that nothing in its order prohibited Acerthorn from proceeding with counsel from defending himself in a lawsuit brought against him, or from filing a claim in which he alleged immediate, extraordinary, and irreparable physical harm. Acerthorn challenges the dismissal of the action and the imposition of filing restrictions. Upon careful de novo review, we conclude that the district court properly dismissed the complaint for failure to state a claim. We also conclude that the court did not abuse its discretion in imposing the filing restrictions because it is undisputed that Acerthorn has proceeded in forma pauperis on at least 16 complaints that proved meritless, and has filed numerous frivolous motions since May 2010. And he had the opportunity to, and did, file objections to the magistrate judge's report recommending the restrictions, restrictions. Court may impose filing restrictions where individual has filed numerous frivolous pleadings. In imposing pre-filing review procedure, appellant's opportunity to respond to materials and arguments was sufficient. Further, in these circumstances, we conclude that the restrictions are not unduly harsh, affirming order that prospectively limited plaintiff to filing one informa pauperis complaint per month. The judgment is affirmed. It's pretty damn telling how much of a piece of work this guy is when the courts start limiting the number of lawsuits he's able to file. While all these cases thus far have made Acerthorn look like a complete buffoon and asshole, nothing comes close to the next case I will be going over, as it shows just how sick and twisted this man truly is. It's unfortunate that the recorded statement from Dr. Holland from the University of Arkansas case and the actions taken as a result had little effect on Acerthorn, as the fantasies of him inflicting harm on his father ended up playing out because Acerthorn decided to stab his elderly father in the face over slow internet speed. The parties to this appeal are appellee Acerthorn's father and his adult son, Acerthorn. At the time of the incident giving rise to this litigation, the adult son was residing with the father. In an attempt to eliminate or reduce previous friction between the father and son, the parties had executed a written agreement setting forth the terms and conditions whereby the son could live in the father's residence. On November 24, 2011, the police were called to the home of the father and found that the father had suffered knife wounds to his face. The son, Acerthorn, was charged and arrested with battery. The son subsequently filed suit against his father, claiming that his father had breached the written contract between the parties that night by failing to provide adequate high-speed internet service. Appellant further claimed that after he confronted his father about the problem with the internet, his father punched him in the face, and then the father purposely cut his own face with a knife to make it appear as if he had been attacked by his son. Appellant asserted in his complaint that his father pressed criminal charges against him, knowing them to be false, and used the alleged attack as a means to circumvent the lease agreement provision of the parties' contract and unlawfully evict appellant from his house. The complaint alleged 6 separate causes of action, including malicious prosecution, abusive process, defamation, breach of contract, conversion, and battery. Appellant subsequently filed an amend complaint, adding additional claims for identity theft, tort of outrage, negligence, and forgery. The case proceeded to a jury trial, and at the conclusion of the trial, the jury was given interrogatories pertaining to only 2 of the 10 claims. Specifically, the jury was instructed on the breach of contract and battery, and returned verdicts in favor of the father on those 2 claims. Therefore, the trial court entered a judgment on jury verdict against plaintiff, and the order stated that Acerthorn's complaint was dismissed. Acerthorn filed a motion for new trial and subsequently filed a new motion for new trial, which were both denied by the trial court. Acerthorn now appeals from the underlying judgment and the order denying his second motion for new trial. On appeal, the son raises 29 arguments for reversal. We dismiss the appeal for lack of a final order because the judgment disposed of only 2 of the son's claims, leaving 8 claims remaining. Rule 2A1 of the Arkansas Rules of Appellate Procedure, civil provides that an appeal may be taken only from a final judgment or decree entered by the trial court. Although the parties did not raise the issue, the question of a final order is a jurisdictional requirement that the appellate court raises on its own in order to avoid piecemeal litigation. Arkansas Rule of Civil Procedure 54B provides that when more than one claim for relief is presented in an action or when multiple parties are involved, an order that adjudicates fewer than all the claims on the right and liabilities of fewer than all the parties is not a final appealable order. In particular, an order that adjudicates fewer than all of the counts of a multi-count complaint is not final. Although Rule 54B provides a method by which the trial court may direct entry of a final order as to fewer than all the claims or parties where there is no attempt to comply with those provisions of Rule 54B, the order is not final and we must dismiss the appeal. In this case, the judgment on appeal provides that the court enters this judgment pursuant to the jury's verdict. However, the verdict forms indicate that the jury did not determine the rights of the parties on a Acerthorn's claims for malicious prosecution, abuse of power, defamation, and conversion, all of which were alleged in Appellant's original complaint. Nor did the jury resolve Acerthorn's claim for identity theft, tort of outage, negligence, or forgery, which were alleged in his amended complaint. Likewise, the trial court's judgment did not dispose of these remaining claims. Although the judgment contains broad language that Acerthorn takes nothing in his complaint against the defendant and the complaint is hereby dismissed with prejudice, the judgment was entered pursuant to the jury's verdict, which was limited to only Appellant's claims for breach of contract and battery. The other 4 claims in Acerthorn's complaint remain unresolved. Moreover, the judgment makes no mention of Appellant's amended complaint or the 4 claims therein. Our Supreme Court has repeatedly held that it is not enough to dismiss some of the parties or to dispose of some of the claims. To be final and appealable, an order must be all of the parties and all of the claims. Because a final order has not been entered disposing of all the claims, we lack jurisdiction of this appeal and it must be dismissed. What happened to his father makes the behavior that Acerthorn exudes all the more concerning. What makes the matter much darker is when the statement from Dr. Holland is taken into consideration. If it is to be believed, then it is not outside the realm of possibility that the situation which resulted in the lawsuit above was in fact premeditated rather than an impulsive act of rage. That being said, either cause of the resulting incident are both likely. We're now going to time jump to June 30th of 2021 when Acerthorn chose to file his most recent lawsuit which caught the internet's attention at large. Acerthorn decided to go all out with this one. People who were named in the lawsuit include Enclave Emily, Echo Wilder, Cretosis, Sophie MP, Just Emmy, BB Fazy, Rogue Internet Man, Sid Alpha, Sheer Perlmutter, Alphabet Incorporated, Discord, YouTube, and Twitch. So far, we've established that Acerthorn is very demanding when it comes to trying to get what he wants, easily angered, and so greedy that he will try to ruin anyone as long as there's a possibility he gets money. And this lawsuit is a culmination of all these wonderful traits that this individual has. The lawsuit spawned from a recording and memeing of a live stream Acerthorn accidentally did, where he was seen roaming around his room shirtless while mumbling to himself and making odd noises. I won't be putting said clip in this video for obvious reasons, but it's very easy to find. He claims that copyright was abused in the instance of people posting and reacting to the stream, which now also expands to all of his streams on his channel, as he will either private them or lock them behind a paywall after they finish. The aggression on Acer's part also increased due to a series of criticisms left on his videos and in DMs with other creators, and even members of his audience who wanted to see him do better. These criticisms ranged from slight tweaks he could make to his content to make it more successful, to him being an absolute mongoloid for thinking that the Morrowind developer team members had scat fetishes due to the environment's color palette being, quote, too brown. Nonetheless, all these instances of criticism are not life-threatening or an Avengers-level threat in any way. Yet, in all instances, Acerthorn would lose his absolute shit. One such situation resulted in a heated back and forth in the comments section of a stream from Cretosis, where he and his group watched Acerthorn's Fallout New Vegas video and reacted to it. Honestly, I'm not going to read through the argument, mainly because it's basically a bunch of unhinged rambling on Acerthorn's end, but also because I don't want to add another 20 minutes to this video because it would push it back by another week. Other important tidbits I do want to mention other than the argument in Cretosis' comments section are that Acerthorn reached out to Echo Wilder complaining about their comments section as well, which led Acer to harassing them via email about how the law works. Sophie and P actually tried seeing things from Acerthorn's perspective at first before the situation spiraled downward. Like all other situations, this devolved into yet another hostile interaction. To give some perspective, here's a clip from a joint live stream Sophie and P and Acerthorn had, where Sophie Ann in a very casual, non-hostile way brings up people who are criticizing Acerthorn and his behavior.
Yo, Acerthorn, I think it's time to get real quick. I've been getting some info from people on Discord and shit telling me that you're suing your parents and stuff.
Okay, you know what? Fuck it. Look.
Like, I've been getting a lot.
I'm not. No. Not on the stream, okay?
Yeah, but it's just like they're spamming my chat and everything.
Not on the fucking stream.
And I've been getting.
Okay, you know what? Fuck this.
I've just been getting a lot of shit, man.
Acerthorn's reaction only further cements the stuff we've already established in this video. Now let's get on with this final lawsuit reading. First amended complaint. Comes now pro se plaintiff Acerthorn, who hereby submits the following amended complaint in the above styled action. Identities of the parties. I am a YouTube channel owner and a Twitch streamer who operates under the pseudonym Acerthorn. My YouTube channel can be found at, and my Twitch channel can be found at, Emily Rebolo YouTuber, who owns and operates two separate YouTube channels, one called Enclave Emily, which can be found at, and another called Freak, which can be found at. She has the email address of redacted, and can be served with process at the following address, also redacted. Tristan Burge, whose last name I had previously erroneously spelled as Burger with an extra R at the end in the original complaint, is another YouTuber who owns the YouTube channel Echo Wilder, which can be found at. He can also be served with process at the following address, redacted. John Doe is another YouTuber who owns and operates the YouTube channel Cretosis, which can be found here. He also runs a server on Discord called the Owl Server, which can be found at. His person Discord account is, and I will also redact. I do not know his real name and address, but he is a member of the YouTube Partner Program, so his name and address is on file with YouTube, so he can get paid for his videos. I plan to obtain his name and address from YouTube when this case progresses to discovery. John Doe number 2 is a YouTuber and Twitch streamer who owns and operates, to my knowledge at the time of this writing, 2 YouTube channels and 1 Twitch channel. The 2 YouTube channels are called Just Emmy, which can be found at, and The Witches Archive, which can be found at. His Twitch channel can be found at. I do not know his real name or address, but he is a member of the Twitch affiliate program, so his name and address is on file with YouTube, so he can get paid for his videos. And so I plan to request that information from YouTube when we get to discovery in this case. John Doe number 3 is a YouTuber who owns and operates the YouTube channel Sid Alpha, which can be found here. I do not know his real name and address, but he is a member of the YouTube Partner Program, so his name and address is on file with YouTube, so he can get paid for his videos. I plan to obtain his name and address from YouTube when this case progresses to discovery. John Doe number 4 is a YouTuber who does not have any videos on YouTube that I know of. He goes by the alias BB Fazy. He has provided his real name and address to YouTube when issuing a DMCA takedown request, so I plan to obtain his name and address from YouTube when this case progresses to discovery. John Doe number 5 is a YouTuber who goes by the online pseudonym Rogue Internet Man. I do not know his real name and address, but he is a member of the YouTube Partner Program, so his name and address is on file with YouTube so he can get paid for his videos. I plan to obtain his name and address from YouTube when this case progresses to discovery. Carl Polano is a resident of Switzerland who goes by the online pseudonym Sophian P. His YouTube and Twitch channels can be found at here and here, respectively. While I do have his address, he would have to be served via the Hague Convention because he is in Switzerland, and he has an established history of willfully and maliciously evading service of process. As a result, I will move for leave to serve him with process via email. Shira Perlmutter is the current Register of Copyrights in the United States Copyright Office, USCO. I wish to include her as a nominal defendant on the issue of registrability pursuant to my rights under the second and third sentences of 17 USC 411A for some of my copyrighted works. Alphabet Incorporated is the parent company of YouTube LLC, which is itself the owner and operator of the eponymous website youtube.com, the largest video sharing website in the world. Both can be served with process at the following registered agent, redacted. Discord Incorporated is a social media website and app that allows people to set up custom chat rooms called servers, where they can discuss various topics and exchange files of 8 megabytes or less with each other. They can be served with process at the following registered agent, redacted. Twitch Interactive Incorporated is the owner and operator of the eponymous website twitch.tv, the largest live streaming website in the world. It can be served with process at the following registered agent, redacted. Jurisdiction and venue. This court has subject matter jurisdiction to hear claims of copyright infringement. This jurisdiction is axiomatic. This court has personal jurisdiction over all 4 corporate defendants, Alphabet, YouTube, Discord, and Twitch, because they are all headquartered in the Northern District of California. This court has personal jurisdiction jurisdiction over Emily Rabollo because she consented to the jurisdiction of the Northern District of California when she issued her DMCA takedown notice. This court has long-arm jurisdiction over all other defendants because they all cooperated and colluded together to ruin my career as a YouTuber and Twitch streamer out of pure hatred, malice, and spite. Therefore, this court has long-arm jurisdiction over all other defendants for the same reason it has long-arm jurisdiction over Frederick Allison in case 421. The following facts are necessary to understand the case. The following is a list of works whose copyrights are owned in whole or in part by me. This is not a comprehensive list of all works that are copyrighted by me, just the ones that are relevant to this case. First, there was a live stream I did on April 10th, 2021. I accidentally turned on my live stream software without realizing I had done it, and so far, for approximately an hour and 43 minutes, my viewers could see me engaging in such mundane activities as walking around my apartment, eating some hot dogs, and watching YouTube videos for my own personal amusement. I registered this stream with USCO on May 26, 2021, and registration was subsequently granted. The registration number is redacted. At one point in the video, you can hear some strange noises which sounded like a dog barking and snarling. These strange noises constitute the most interesting part of an otherwise boring video, and therefore constitute the heart of that work. I did not wear a shirt for this live stream. It was the only video or live stream I have ever done without a shirt on, which means that anytime anyone else depicts me without a shirt, it necessarily comes from that stream. There was one time during the stream when you could hear me saying, "I will kill you." I do not remember saying this, so I cannot tell you what I was thinking at the time or why I said this. However, I was alone at the time, so I could not possibly have been issuing a genuine threat, since my words had no intended audience. Despite this lack of criminality, many people see it as evidence that I am homicidal and psychotic. I transferred this livestream to my YouTube channel and restricted viewing it to only those who paid my channel $20 per month. As of the time of this writing, nobody has paid that fee. Also, there is no way to download it directly from Twitch, where the stream was originally broadcast. This means that the only way anyone could possibly have seen any proportions of that stream is by illegally downloading it. On April 18th, 2021, I did a collaborative live stream with Carl Polano on Twitch. Polano and I are co-authors of this stream, meaning that while Polano may distribute this and grant other people permission to distribute this without my permission, if he does so, I am entitled to 50% of the revenue incurred from said distribution. I registered this stream with USCO on September 14th, 2021, and registration was subsequently granted. This registration number is redacted. On November 24th, 2021, I published a 50-second video on my channel called Corrections, Series is Cancelled and Here's Why, #shorts. I am the sole owner of the copyright to this video. I registered this video with USCO on December 11th, 2021, and registration was subsequently granted. The registration number is redacted. On October 13th, 2019, I published a video to my YouTube channel called Fallout New Vegas Retrospective. I am the sole copyright holder to that video. It used footage of the video game Fallout New Vegas, but I do so in order to review and critique it, so I believe it falls under fair use if Bethesda Softworks, the owner of the copyright to that game, ever wanted to sue me for copyright infringement. I registered this video with USCO on December 17th, 2021, and registration was subsequently granted. The registration number is redacted. Because my registration of my copyright occurred more than 3 months after publication, and because the infringements predate the registration, this is the one copyrighted work which I cannot recover statutory damages. On December 18th, 2021, I did a live stream debate with a guest star who went by the online pseudonym Skippity Dippity. The title of this live stream was Fallout New Vegas Sucks and Here's Why Livestream Debate. I believe I am the sole copyright holder of this video, although Skippity Dippity would consider himself a co-author. If Skippity were to ever wish to sue me for recognition as a co-author, he would have to make his true identity known and cannot hide behind the anonymity of the internet. I registered this stream with USCO on December 22nd, 2021, and registration was subsequently granted. The registration number is redacted. On December 9th, 2021, I applied for registration of 10 different 2D images. Those images were titled as follows. I'm not going to read that. At the time I applied for the registration, all 10 of these 2D images were unpublished, so I was well within my rights to register up to 10 of them at once. The channel art and channel icon were both shown to members of my Discord server on December 12th, 2021, but that was 3 days after I applied for registration. The 8 watermarks have since been published, but on different dates. All 10 of these 2D images are comprised predominantly of a blue honeycomb background with text overlaying it. The blue honeycomb consisted of high blue hexagons with space in between the hexagons filled by a gradient. The gradient starts as a Polynesian shade of blue on either side, slowly morphing into periwinkle blue in the center before morphing back into Polynesian blue on the other side. This honeycomb background was created entirely by me. I made this background from whole cloth using MS Paint and NCH VideoPad, my personal favorite video and image editing software. It is not a stock image. While all these 2D images use the aforementioned blue honeycomb background, the Acerthorn channel icon contains an additional splash of creativity on my end. The hexagons are actually partially stretched out. The reason for this is because since the channel icon is supposed to be circular, I applied a fisheye filter to the honeycomb background in order to create the illusion that it is wrapped around a ball. Because of the facts mentioned in lines 35 to 37, I believe these 2D images satisfy the human authorship and minimum creative spark elements to be eligible for copyright protection. That's a stretch. Despite being eligible, USCO refused to register the copyright, claiming that it lacked sufficient creativity. For this reason, I seek to challenge USCO's decision in this case, while also suing for the infringement of these images. All of these copyrighted works may sound confusing, so to assist the court and the defendants in navigating all these copyrighted works, please find, attached to this complaint, Exhibit A, a chart I created which lays out all the different copyrighted works, their dates of first publication, the dates in which I applied for registration, whether their registrations were granted or refused by USCO, and if registration was granted, what the registration number is. There is another currently pending before this court. The judge in that case has already seen fit to relate this case to that one. See document 9. I will refer to that case as the sister case from now on. The outcome of that case will likely have a great impact on the outcome of this case. For example, the question of whether my April 10th, 2021 stream is even protected by copyright in the first instance, and the question of whether the individual defendants have harassed and doxed me, and if so, whether they have acted with sufficient actual malice as to nullify any potential claim, are all likely to be adjudicated in that case. If they are so adjudicated, they would create res judicata, which would prevent those same issues from being re-litigated in the instant case. In addition to copyright infringement, the individual defendants, with the exception of Shira Perlmutter, have joined together to engage in a long-standing and widespread pattern of harassment, doxing, and dogpiling against me. Some joined in the hate campaign later than others, but they are all guilty of contributing to the harassment in one form or another. Please understand that I will not be outlining every single instance of harassment right here in the complaint. Since I am not suing for the harassment in itself, there is no need for me to state the underlying facts in any specificity. Instead, I am only seeking to use this harassment to nullify any potential claims to fair use, to the extent that said defense is even available in the first instance. While I will eventually be required to substantiate these allegations with evidence, I do not feel that listing our specific acts with specific dates should be required at this stage. The copyright infringement and DMCA fraud claims, I will indeed allege specific acts, specific actors, specific URLs, specific dates, and, to the extent I know them, specific times. First, there is the harassment and doxing I have already discussed in the sister case, Acerthorn v. Polano. As of document 9, this case is being overseen by Judge Jeffrey White, the same judge as in that case. As a result, he is likely to be intimately familiar with the harassment, doxing, and dogpiling I have endured in that case. There is no need for me to discuss that harassment in intimate detail, but for the sake of being thorough, I hereby incorporate by reference in the contents of that case. Defendant Kuritosis owns a Discord called the Owl server, which you can access here. In that server, there used to be a thread called Acerthorn Pinata Bashing, or APB for short. As the name would suggest, this thread is dedicated to exclusively harassing, doxing, and dogpiling me out of pure malice and spite. Those participating in APB were constantly searching my entire life's worth of personal history and sharing it with other people, an act known as doxing in internet terms, including my medical records, information regarding a crime I was charged with over a decade ago where I wasn't even convicted, and even finding numerous porn websites and dating websites where users have pseudonyms similar to my own, so they can speculate what sort of kinky stuff I may or may not be into in the bedroom. They are also constantly monitoring my social media activities like vultures, looking for anything they can find, literally any sentence I might say, or a single twitch of my eyebrow that I might do on camera that would give them more ammunition to use in their never-ending effort to harass, dox, and dogpile me. There is no legitimate motive for anyone who participates in APB, just pure hatred, pure malice, and pure spite. Carl Polano and Frederick Allison, two of the three individual defendants in the sister case, have joined APB since late November of 2021. Prior to them participating in APB, it was primarily dedicated to criticizing my YouTube videos, but nothing more. However, once Polano and Allison came in, they began circulating numerous bits of my personal information, such as the content described above. Once they began doing that, many other people joined in, an internet phenomenon known as dogpiling, until it ceased to be about legitimate criticism of my YouTube videos and became nothing but harassment and doxing against me. The individual defendants in the instant case participate regularly in APB. Admittedly, Tristan Berger participates less frequently than Emily Rabolo, but both are regular participants. As a result, I believe their actions should constitute bad faith and malice, which should nullify any affirmative defenses, including fair use, they may have to copyright infringement according to the legal doctrines of abuse of rights and unclean hands. In addition to the Acerthorn Pinata bashing thread, I have also been subject to widespread harassment, doxing, and dogpiling across many different websites, as well as over private contacts, such as my email address and phone number. I have received numerous tweets on my Twitter account cussing me out, calling me various insults, and publicly sharing my personal information. I have people call my phone number and threaten to bomb my house if I do not stop issuing DMCA takedowns, which they disagree with. I have had people create numerous YouTube videos and Twitch streams that are dedicated almost exclusively to revealing my personal information. I have had people contact me over email and either hurl insults at me or show me various pieces of my personal information, such as porn accounts or dating profiles, that they claim to have found about me and demand that I justify the existence of. In short, I have been through hell the past few months. I'm going to cut the reading from the document here and skip a good number of pages down to his justifications and demands. The reason I'm doing this is because this part of the file gets very repetitive and doesn't need to have time added to this video for it. I will be leaving a link to a Google Drive with all the documents I read off of for this video in the description and the pinned comment for those of you who are extra curious on reading the fine details. Just a heads up that the info redacted in this video will also be redacted in the Google Drive. DMCA misrepresentation. To state a claim for DMCA misrepresentation, I must allege A. The defendant issued a DMCA takedown against one or more of my online submissions, B. The takedown contained materially false statements by the issuer, C. The issuer knew the statements in question were false, and D. The ISP, in this case YouTube, relied on those misrepresentations when removing the online content to my detriment. Line 132 of this complaint satisfies the first and fourth elements. Lines 124 to 127 adequately allege the second and third elements. Therefore, I have plausibly stated a claim for DMCA misrepresentation, and that defendant BB Fazy acted with actual malice. Relief requested. I request the following relief from the defendants. Prospective injunctive relief against Perlmutter. First, I request an injunction against Shira Perlmutter to register my copyright for my 10 2D images, with December 9th, 2021 as effective date of registration. Next, I ask that all the individual defendants be ordered to A. Remove any instances of copyright infringement from their social media accounts and cloud storage accounts. B. Submit all their computers and smartphones for impounding to a third party so that their devices may be cleansed of any instances of unauthorized infringements of my copyright pursuant to 17 U.S.C. 503. C. To cease and desist any infringement of my copyright, and D. To remove from any website any instances of my copyright that would not have existed but for their infringement. I have alleged 26 different infringements of my copyright. For two of those infringements, number 16 and number 17, I am limited to actual damages. For one of those infringements, infringement number 23, I may opt for actual damages. This leaves a total of 23 other acts of infringement where I am eligible for statutory damages. I request statutory damages of $150,000 for each count of infringement. Carl Polano should be held contributorily liable for each of these counts of infringement, whereas all other defendants should only be held liable for the infringements they themselves committed, or in the case of YouTube, which they intentionally permitted to remain on their platform. This makes for a grand total of $3,450,000 across the various defendants. For infringements number 16 and number 17 and number 23, I request to be compensated all of the profits, however much that may be, that Kretosis earned from their streams which infringed on my content. For infringement number 23, I request actual damages of $20 for every view that Sid Alpha's video about me earns before it is taken down. Even if the corporate defendants have safe harbor for everything else, such as Discord or Twitch, I can still obtain limited prospective injunctive relief against them pursuant to 17 USC 512. Pursuant to this subsection, I ask that YouTube LLC, Alphabet Inc., Discord Inc., and Twitch Interactive Inc. all be ordered to A. Remove any infringements of my copyright that have not already been removed pursuant to 512. B. Permanently terminate the accounts owned by the individual defendants that have not already been terminated pursuant to 512. And C. Take reasonable measures pursuant to 512 to prevent any of the individual defendants from creating any new accounts. So TLDR of that entire thing, he wants a lot of money from these people, and he wants every single one of them to be deplatformed permanently. The end of this document has a blank conclusion. However, as of July 11th, 2022, this case has thankfully been thrown out of court. It's truly despicable to see a man exploit a legal loophole that was created for those less fortunate to represent themselves fairly in court, and use it to go after just about anyone and anything he pleases. This behavior is absolutely unacceptable, and the unfortunate truth, despite this victory, is that Acerthorn will be back at filing lawsuits against people the minute he gets a chance. But let's end on a more positive note. I want to congratulate everyone who Acerthorn was currently suing for coming out on top. You guys deserve this victory. The rabbit hole goes far deeper beyond the lawsuits. However, I didn't want to derail from being objective in this video. That being said, I may or may not make a second video dedicated strictly to the antics Acerthorn has gotten himself into online with other communities, but that's just an idea as of right now. Hopefully you guys enjoyed the video, and if you made it this far, you're truly awesome. Don't forget to like and subscribe and share this video. Shout out to my channel members DevEnd, GG Evan, Stormiel, Nizand, and Kayla May. Y'all are rock stars. Until next time, take care of yourselves, and I'll see you in the next one. Peace out.